Okay, welcome everyone to today's webinar. I'd like to introduce Greg Kaur, the Division Director with the Monitoring and Improvement Planning Division at OSEP. Greg?
Good afternoon, everybody. This is Greg Kaur at the Monitoring and State Improvement Planning Division of the Office of Special Education Programs, and I want to welcome you to our monthly TA call that we hold the second Thursday of every month. Those of you who join us each month already know that. For folks that are new to the call, we welcome you and invite you to tune in every month for different topics. We usually try to announce those a couple weeks in advance. So today's topic, we're actually going to have two. The first is going to be an overview of frequently asked questions on prior approval, an issue that many states have asked us about over the past months. I think we have some good responses for you on that. Providing that overview is Susan Kaufman from our Physical Accountability Work Group and Jennifer Simpson. After that part of the presentation, we are going to review some recent policy decisions that I think will be of interest to you. And we have actually three of our staff here who are going to provide the overviews. We have Jessica Spataro, who's actually not in our division. She's from OSER's Office of Policy and Planning. And then Lisa Pagano and Laura Duos, all both from the Monitoring and State Improvement Planning Division. So without further ado, I'm going to turn the call over to Susan Kaufman.
Thank you, Greg. All right. You can move to the next slide, please. As some of you may already know, on October 29th, 2019, Mark Schultz, Commissioner of the Rehabilitative Services Administration, delegated the authority to perform the functions and duties of the Assistant Secretary for the Office of Special Education and Rehabilitative Services, OSERS, released a frequently asked questions document on prior approval. This FAQ covers programs under the Office of Special Education Programs, OSEP, and the Rehabilitative Services Administration. This FAQ addresses new prior approval guidance on two direct cost categories associated with OSEP and RSA formula grants. This document was released in interim final form, and the final form of the document will be available upon publication in the Federal Register. We're very excited to share the details of this document with you today. Next slide. For the purposes of this presentation, we will only be addressing OSEP's formula grants under the Individuals with Disabilities Education Act. This guidance is applicable to all IDA formula grants. Next slide. Under the OMB uniform guidance, certain items of cost require prior written approval from the federal awarding agency. The purpose of this FAQ is to provide new guidance to OSERS grantees for two specific direct cost categories. Those categories include certain participant support costs and certain general equipment costs. This FAQ is intended to ease burden on state grantees, provide states with flexibility with use of IDA funds, while still ensuring programmatic and fiscal accountability. Next slide, please. For your reference, we provided you with the regulatory citations from the OMB uniform guidance and from IDA for each of the categories of costs that we will be discussing. These are contained throughout the FAQ. Next slide, please. With this new prior approval guidance, grantees no longer need to submit separate individual requests for prior approval for certain participant support costs and certain general purpose equipment expenditures that fall within the scope of the FAQ guidance document. Previously, As many of you are familiar with, OSER's process for prior approval consisted of state education agencies and lead agencies submitting requests through the IDA Part C grant application, the NCSI template for state requests of prior approval for participant support costs, or through guidance provided by OSEP state leads. Now I'm going to hand it over to Jennifer Simpson to discuss the specific details of this new prior approval guidance and what this means for you.
Thank you, Susan. All right, what does this mean? Well, it means that OSERS is granting prior approval for 4 categories of participant support costs. Next slide, please. And these 4 categories of participant support costs are specific to OSEP formula grants. First of all, with regard to state advisory panels for SEAs and state interagency coordinating councils for LAs, there has been no change to the previous guidance. That means that SEAs and LAs still do not have to submit prior approval requests for participant support costs related to meetings required by IDEA, including state advisory panel meetings and ICC meetings. In addition, the FAQ provides 3 new flexibilities for OSEP grantees, and these include the following. OSERS is granting prior approval for participant support costs incurred during the provision of IDEA special education and related services, and this includes services under IEPs and IFSPs. Also, OSERS is granting prior approval for any participant support costs that do not exceed a total of $5,000 per individual participant or trainee per conference, training, or event. And OSERS is granting prior approval for all participant support costs incurred by LEAs under IDEA Part B. All participant support costs incurred by LEAs under IDEA Part B are costs that SEAs are responsible for reviewing as part of their general supervision responsibilities under IDEA and OMB uniform guidance. Next slide, please. For Part B programs, we want you to take special notes. SEAs are responsible for reviewing prior approval requests for their subgrantees. So, for example, just as SEAs are responsible for reviewing prior approval requests for the use of funds for equipment, SEAs can similarly ensure that the use of IDA funds by its LEAs for participant support costs are allowable or for allowable purposes, and SEAs should conduct appropriate reviews. For additional information about this topic, see FAQ number 6D in the FAQ guidance document. However, also note that OSEP reviews the right to review these costs through its monitoring or audit processes as determined appropriate to ensure compliance with applicable federal requirements. Next slide, please. There's some additional guidance we want to bring to your attention that is described within the FAQ document related to prior approvals. One is that current prior approval requests for participant support costs under IDEA Part B and C now fall under the prior approval FAQ guidance, and OSEP will not be reviewing SEA and LA requests if they meet these requirements. Specific to Part C programs, states that submitted prior approval information through their FFY 2019 grant application and were required by OSEP to submit additional information no longer need to submit that information to OSEP if the per participant cost does not exceed $5,000, which is consistent with the FAQ. Also, OSEP is granting prior approval to grantees that make budget revisions for participant support costs under both IDEA Parts B and C. Next slide, please. The second direct cost category that is referenced in the FAQ document relates to equipment. With regard to SEAs, we want to point out that SEAs continue to have the authority to review and approve LEA requests. So this has not changed as a result of the FAQ. This remains in place. For IDA Part B and Part C, OSEP is granting prior approval for equipment that is identified on or directly related to the implementation of an IEP or an IFSP. This means, via the FAQ, OSEP is now granting prior approval for equipment that is charged to the IDA Part B and Part C grant funds for the delivery of services to ensure the timely delivery of those services. SEAs and LAs no longer must submit prior approval requests to OSEP for equipment that is child-specific and identified on or directly related to the implementation of IEPs or IFSPs. Next slide, please. Now, for all of the direct costs from IDA Part B and C funds that fall outside the scope of the FAQ guidance for participant support costs and equipment, those costs will continue to need prior approval from OSEP. So you will continue to submit that information to our office. Next slide, please. If you have any questions about the FAQ, you can contact Matt Schneer, who's the ADD assigned to the Fiscal Accountability Implementation Team. And his email address is presented here, matthew.schneer@ed.gov. And in addition, we provided the link to the FAQ document. This document was emailed to all state directors and Part C coordinators. However, you can contact us if you can't access the link, and we'll make sure to provide that information to you. Thank you. At this time, we're going to turn things over to our policy team.
Okay, so one thing I wanted to say, if there are questions in the chat, Jennifer Reed, who's assisting us with this call, will capture all that information and get it to us, and we'll try to provide timely responses on that. Now we move to the second part of our call, and we've got Jessica, Lisa, and Laura here to provide us with policy updates. I think they can see it. I don't know who starts.
Jessica.
Jessica?
Mm-hmm.
Okay.
Thanks,
Jessica
Greg.
Spataro.
Thanks, Greg. Good afternoon, everyone. Again, I'm Jessica Spataro with the Office of Policy and Planning within OSERS, and I'm going to talk a little bit about the question and answers document on increasing post-secondary opportunities and success for students and youth with disabilities. I'm sure you're aware that one of the priorities of the department is ensuring that students and youth with disabilities are held to high expectations and have resources and supports needed to expand their learning opportunities and to prepare them for success in post-secondary education or careers. Next slide, please. Thank you. The department had heard concerns from stakeholders regarding some confusion in the field about whether and when IDEA and VR funds could be used to support dual enrollment or comprehensive transition and other post-secondary education programs for students and youth with disabilities. We understood that there was a need for clarification, as there are instances in which some special education and related services under the IDEA may also be services provided under the VR program. In addition, pre-employment transition services and transition services under the Rehabilitation Act may be categorized as both VR services under the VR program and as special education or related services under the IDEA. Therefore, OSERS and the Office of Post-Secondary Education released this question and answers document to provide clarification around these issues. The Q&A document describes how SEAs, LEAs, and state VR agencies may coordinate to assist students and youth with disabilities, including students and youth with intellectual disabilities. Next slide, please. Specifically, the Q&A addresses the following topics: the opportunity for students with disabilities to enroll in post-secondary education programs while still in high school, the opportunity for students and youth with disabilities to enroll in comprehensive transition and other post-secondary programs for individuals with disabilities after leaving high school, the coordination of transition-related services that students with disabilities may receive under the IDEA and the VR program, and also the financial aid available to students with disabilities who are enrolled in comprehensive transition and post-secondary education programs for students with intellectual disabilities that are offered at institutions of higher education under the Higher Education Act. We hope that this Q&A will be a helpful resource to families, IEP teams, and state VR agencies as they collaborate to find ways to increase post-secondary opportunities and success for students and youth with disabilities. For any questions regarding this document, my email address is on the slide. It's jessica.spataro@ed.gov. You can feel free to email me, and we're collecting questions for any follow-up guidance that might be needed. And I think I'm going to turn over to Lisa to continue.
Thanks. My turn. Hi, this is Lisa Pagano. As Greg mentioned, I work in the Monitoring State Improvement Planning Division at OSEP. You'll find on almost all of OSEP's recent letters my name and contact information if you have any questions about the policy documents that we issue here at OSEP. Can we move to the next slide, please? So I'm going to present on a couple of our recent policy letters. We're so pleased today to be able to talk about some letters we've issued that should be of interest to both those of you who work in Part C, early intervention programs, as well as our Part B partners. Later on, when my colleague Laura speaks, she's going to share a link where you can find these letters. Hopefully by now you've been using our IDEA website. All of our policy documents are posted there, and we hope that you're finding those to be a great resource to you as you're working very hard to implement the requirements of IDEA. So the first letter I'm going to talk about today is a recent letter we issued, Letter to Anonymous. You'll note that we issued quite a few letters to Anonymous. The reason they're called Anonymous is usually the writer is perhaps a parent, could be a service provider, someone who really does not care to be named in our response, but the issues are of such interest, we think that it's important to share with everyone nationally, and so those letters are all tagged Letter to Anonymous. So in this case, our Letter to Anonymous was from a parent of a Part B eligible child. You know, this letter that we're highlighting today, it raises an interesting question that we had not addressed previously regarding state complaints resolved under Part B of IDEA. And that issue is whether compensatory services ordered through an IDEA complaint resolution must be provided even after a child relocates to another state. Interestingly enough, OSEP had responded to a similar question regarding Part C and children who had exited the program and were later determined to have been denied appropriate early intervention services. So that letter was issued back in 2009, and that's our letter to Whipple. So in Letter to Whipple, OSEP first wrote about the continuing obligation to provide compensatory services to children who were not even eligible for Part C services any longer from a state, such as a child who had aged out of the program or had moved out of state. And in that letter, and I know this is going to interest you so much, you're going to go back and you're going to look for that letter, and you can read for yourself. But what OSEP said in that letter is that if it's determined that compensatory services are appropriate to remedy a past denial of appropriate services, then those services need to be provided. And in the case where a family moves out of state before an IFSP team has come together to determine the appropriateness of compensatory services, then the state needs to make reasonable efforts to locate the child and family and find out whether the parents are interested in participating in an IFSP meeting to determine whether compensatory services are appropriate for that child. So that was if the family moves before the IFSP team ever comes together to make the decision. If the family moved out of state after the IFSP team had met and determined compensatory services were needed, the state would then need to make reasonable efforts to contact the parents to find out if they want to receive the compensatory services as indicated by the IFSP team. And if those parents elect to receive compensatory services, the state could provide those services through contractual arrangements where the family currently resides if it wouldn't be feasible for the previous state service providers to reach the child in his or her new location. So, we've got something going on our screen. Okay, let me try to focus and not get distracted. Okay, so that's what OSEP said about ensuring compensatory services required as a result of a state complaint for Part C, even if the child had exited. So let's fast forward to present day in our October letter to Anonymous, where we were asked by a parent whether her child would continue to be owed compensatory service hours after her family relocated to another state. And in this case, the parent had filed a complaint with the SEA, this is Part B, and the SEA found as a result of its complaint resolution, the child had been denied a free appropriate public education, or FAQs. So you'll see in our letter to Anonymous that we state that once the SEA issues a written decision in response to a state complaint, the SEA, consistent with its general supervisory and monitoring responsibilities, must ensure that the public agency involved in the complaint implements that decision in a timely manner. We also note, and this is nothing new, this is all in the regulations, that the IDA regulations require each state to have procedures in place for effective implementation of an SEA's final complaint decision, if needed, including technical assistance activities, negotiations, and corrective actions to achieve compliance. And in our letter to Anonymous, we go on to say a state's responsibility to ensure implementation of a final decision in the state complaint resolution generally would continue until that ordered corrective action had been fully implemented. We know that in some cases this will really be a fact-specific determination. In some cases, it may not make sense for a specific remedy or action to be carried out once that parent left the state. And the example in the letter we give is requiring the IEP team to develop a new IEP. You know, if the parent and child has already moved out of the state, it likely wouldn't make sense for that to occur. They would have their new public agency develop the IEP. But if an SEA's complaint resolution decision ordered relief, such as compensatory education, that can reasonably be implemented in a new state, and the parent does not reject the remaining compensatory services, then the SEA must ensure the decision is implemented in the new state. So now that we have the October 23rd letter to Anonymous, we have letters under both Part B and Part C that address the obligation of a state to ensure that those corrective actions required by a state complaint are carried out even if a child has relocated to another state. So I hope that overview is helpful to you. I encourage you to go and take a look at the letter. Again, you'll find my name and contact information should you have any specific questions about that letter. I'm now going to talk about the second letter that you see on the slide, and that's our September 9th, 2019 letter to Roland. And this letter is important, and one of the things it really drives home is the importance of making individualized determinations of special education-related services and making educational placement decisions in conformance with the least restrictive environment provisions of IDEA. And while this is a Part B letter, I think it can give you Part C folks a little bit to think about too, in terms of how individualization is so important in all of our programs for infants, toddlers, children, and youth with disabilities. So in the letter that came to OSEP, we were asked a series of questions from an advocate who was concerned about a preschool educational program that was sort of packaged to include a number of related services and special education. And the writer raised some questions about whether children who would be placed in these kind of preschool programs, whether a public agency could restrict the types of related services or the amount of related services that could be put on a child's IEP simply because the child was placed in this special type of program. So again, an important reminder from this letter is that the services and supports that are required for a free, appropriate public education must be determined first. And then the team is going to look, the placement team will look at making that educational placement based upon, among other factors, but starting with what's required in the IEP. So we go on in this letter to talk about those decisions, about programs and services, and the setting where the services will be provided must be made on an individual basis in light of each child's unique needs. And for those of you who are following, the Andrew F. decision and some of the implementation of that, in light of each child's unique needs is very important language to keep in mind. Again, driving home the individualization for each child's program. In our letter, we have some very specific language that I wanted to highlight, where we say, in general, a policy that prohibits the provision of specific related services or restricts the amount or type of services that can be provided to a child based solely on the particular setting in which the child is placed, regardless of the child's individual needs, would not be consistent with IDEA. And I'm going to stop and ask you something that I don't know. When we were working on this letter, I would frequently say it just really reminded me of the TV commercial, and I thought it was Ragu, where I know you're thinking, what does this have to do with anything? But there was a TV commercial, and it was actually about Prego spaghetti sauce. Ragu? I'm getting blank looks from my colleagues here. But anyway, in this advertisement, the father, who's an actor in the commercial, was being really critical about his son using a jarred spaghetti sauce. And he starts grilling his son about, what about this spice? What about that spice? And the son kept saying, it's in there, right? And that kind of approach is what this program felt like, that when the parent or advocates were saying, well, what about speech therapy? What about occupational therapy? Oh, don't worry, it's in there. This program that we've developed will meet all of the child's needs. So Prego does not work with faith, right? It has to be an individualized determination, and the child's IEP must include the specific amount of special ed and related services and supplementary aids and services that the public agency is going to provide to that child, and that IEP must state this clearly so that the level of the agency's commitment of resources is clear to parents and IEP team members. Further, those IEPs, and we get questions about this frequently, not necessarily all in policy, but through our customer service team. How specific does the IEP need to be about what's going to be provided to a child? And what we have said in our policy letters, including this one, is that the amount of time to be committed to each of the various services to be provided must be appropriate to the specific service and clearly stated in the IEP in a manner that can be understood by all involved in the development and implementation of the IEP. So that parent needs to know very clearly, the child's teacher needs to know very clearly what the commitment of that public agency is to the provision of services that that team has determined to be safe for that child. In closing on this particular letter, the overriding rule is that placement decisions must be determined on an individual case-by-case basis, depending on each child's unique needs and circumstances, and based on the child's IEP. In all cases, however, placement decisions must not be made solely on factors such as category of disability, severity of disability, the availability of special ed and related services, configuration of the service delivery system, availability of space, or administrative convenience. And those words probably sound familiar. Those have been put forth by OSEP, have been written in the analysis of comments and changes with the 1999 regs, and then again with the 2006 regulations. So I appreciate your attention and hope that hearing about these two letters will get you curious to read the letters themselves. I'm going to turn things over now to my colleague Laura Duas, who is going to talk about the next two letters. If you could advance the slide, please.
Thanks, Lisa. We do have two additional letters, one Part B and one Part C. The first one I'll talk about is our May 2nd, 2019 letter to Holler, and this addresses whether a school district may invite an observer to an IEP team meeting. This came to us as a result of a school district's operating procedures, which stated that any person who is invited to the IEP team meeting must be included on the invitation sheet, regardless of whether they were participating or not. And so that led to the question of why would you have someone in, or could you have someone in an IEP team meeting if they were not going to participate, and such as an observer, someone who was there to be trained, or someone who was there as kind of a supervisor to oversee the process. And so this is a kind of a two-prong analysis that we took when answering this question. The first goes to the IEP requirements, and I'm sure, as you know, under 321A6 that the IEP team can include, at the discretion of the parent or public agency, other individuals who have knowledge or special expertise regarding the child, including related services personnel as appropriate. And those folks can be directly involved with the child, as well as those who do not know the child personally, but who have expertise in an instructional method or procedure. And the person who determines whether that special expertise exists that determination is made by the party that is inviting the individual. So if the LEA is inviting the individual to be an observer, they have, or to attend the IEP team, they have the discretion to determine whether they have this special expertise. With regard to folks attending IEP meetings who are only observing, we would caution that that the initial legislative history of IDA said that attendance at IEP team meetings should be limited to those who have an intense interest in the child, and that can contribute about appropriate services to the child. So as you're making that determination, that we've asked that you consider that history. If the observer cannot be invited to the IEP team meeting based on the special expertise regulations, then you would look to the confidentiality provisions, and that's kind of the second part of the letter. And I'm sure as you know that before releasing personally identifiable information, you must get consent from the parent or meet one of the exceptions under FERPA. So you would need parental consent before inviting an observer if that observer did not meet the special expertise provision and the IEP requirements. Again, What we've said in the past, though, is that we ask that you be mindful of the interests of the child, including the confidential and sensitive nature of discussions that occur and the personally identifiable information that is exchanged during IEP meetings, that you take all of that into consideration before inviting someone who really won't be participating in either providing information about the child or instruction or methodologies that may assist the child. So that was the first letter. Our second letter is a Part C letter to Eiserman from last December. And it addresses a series of questions on the evaluation process for an infant or toddler suspected of being deaf or hard of hearing. And what you'll find in the letter, the first question asked is whether screening should be included as part of an evaluation for an infant or toddler suspected of being deaf or hard of hearing. And on page 2 of this letter, I won't go through it all, but there is a nice summary of the evaluation requirements, the assessment requirements, and the screening requirements. So it may be something for you to tag in the future if you just need something in it's not necessarily in red form, but is a nice summary of those requirements. But if the parent consents to the screening and the screening indicates that the child is suspected of having a disability, the evaluation then must be conducted. And additionally, if the lead agency or EIS provider has determined that the child is not suspected of having a disability, and the parent of the child requests and consent to an evaluation at any time during the screening process, an evaluation of the child must also be conducted. So those are kind of the important points we want to point out. But again, you'll see a nice summary of the screening procedures in this letter. The other questions are a little more specific. They ask what do you do when there's been a previous hearing screening, such as a newborn screening? How's that incorporated into an evaluation? And as you know, Part C permits the review of records that are related to a child's current health status or medical history to establish eligibility. But if after looking at those records, those older screenings, you need additional information to make an eligibility determination, and then you would need to go ahead and perform that evaluation in order to do it. So if the previous screening provides enough information, that's fine, but just know that you may also have to complete an additional evaluation. They also asked how do Part C programs ensure that a hearing or screening or evaluation is also completed in a timely manner when a child is determined to be eligible for Part C services based on an established condition. And again, this is similar, that if you have established eligibility based on a medical condition, but you also have concerns about the child's hearing, then you would go ahead and complete an assessment of the child as well based on those concerns. And finally, a question was asked, if an initial evaluation has been initiated and the child requires treatment to resolve any temporary medical conditions before the evaluation can be completed, what do you do? And what we've said is that that can be an exceptional family circumstance if the child does have a medical issue. At that point, you would document the exceptional family circumstance and then complete the evaluation and assessment as soon as possible, practical for the family. So I think there's a lot in this letter. I didn't talk through all of it, but it is I just think a nice summary of the assessment and procedures, screening procedures for under Part C. As Lisa said, as you'll see the last bullet on the third, on the last slide here, the third bullet, all of our policy letters are on the IDA website. They are listed chronologically by year, or if there's a specific letter or topic you are looking for, you can search by that as well. Next slide, please. And lastly, just a reminder, for questions on the prior approval FAQ, you would contact Shneer, and then, as Lisa said, she is the contact for OSEP policy letters, so feel free to contact her by email. With that, I'll turn it back to Brett.
Okay. Thank you, Laura and Lisa. And Jessica. Lisa made some references to particular spaghetti sauces. As she described her letter, and I just want to make it clear that was for example purposes only.
That's right, I'm not promoting
It's not representative endorsement by the department of any particular trans. But thank you all, and also thank you, Susan and Jennifer, for briefing us on the prior approval memo. I think that wraps up today's call. If you have questions, you can email them to one of the two folks here on the screen. Also, Jennifer Reed will be capturing any questions that are in the chat. We can't see those from where we are, but she'll be providing those to us. Our next call will be on Thursday, December 12th at 4 o'clock. I hope you can join us then. In the meantime, I hope everybody has a great Thanksgiving break. This will conclude our call. Thank you.
Thank you, everyone. Have a wonderful day.